Good morning, everybody, or good afternoon. Thank you for joining. We had a little bit of a technical difficulty, but we're back, we're ready. My name is Christy McKenzie. I am Assistant Coordinator of Neighborhood Services for the Department of Senior Services of Erie County. I'd like to welcome you all to the virtual 2020 Elder Law Day Summer Series. This series will be running a session every Wednesday through the end of September. If you'd like more information about our series, please visit erie.gov/ELD to register for any upcoming sessions. This session will also be recorded, so we'll be able to view it at a later date. And please feel free to use our Q&A panel to the right side to ask any questions during the presentation. Please also refrain from including any personal information in those questions. I'd like to take a minute to thank those individuals who have helped make this summer series possible. Our County Executive, Mark Hollengard, Karen Nicholson, the CEO for the Center for Elder Law and Justice, and our Senior Services Commissioner, David Shea. We also have two guest speakers today. First, we have Sarah Hedden. Sarah is a supervising attorney with the Kinship Care Legal Services Program at the Center for Elder Law and Justice. She represents non-parent relatives of children at risk of placement in foster care. Sarah is a member of the Advisory Council to the Supporting Grandparents Raising Grandchildren Act. We also have Judge Hedden Carter joining us shortly. Judge Carter is a supervising judge of the family courts in the 8th Judicial District. Prior to the bench, Judge Carter served as an attorney for children in cases involving custody, visitation, juvenile delinquents, and persons in need of supervision. I will turn over the presentation to Sarah.
Thank you, Christine. Good morning, everybody. So as Christine said, I'm the supervising attorney at the Center for Elder Law and Justice, and the bulk of my practice is representation of kinship caregivers. So before I get too much into kinship care, I want to touch on grandparent visitation, because I imagine that's probably of interest to a lot of folks attending today, and it's something that I get asked about a lot, even though we don't represent people looking for visitation. I want to just share some information about it. So anyone could file for custody of a child, but when it comes to visitation, only 3 sets of people can petition family court and ask for visitation with a child. And by child, I mean someone under the age of 18. So anyone over 18 is an adult, and they can have whatever associations they want. So those who can ask for visitation in court would be grandparents, parents, or siblings. So a great-grandparent would not be able to, or an aunt or an uncle, even though they may have a really close relationship with that child. It is only limited to grandparents, parents, and siblings or half-siblings. When it comes to grandparent visitation, that grandparent would have to show that they have had been a big part in the child's life, and they are no longer allowed to have access for some reason. The parent has blocked that access, or that they have tried to be a part of the child's life but have not been able to. So maybe mom and dad had a baby, and baby's now 6 or 12 months old, and grandma hasn't been allowed to visit for whatever reason. Another situation could be that the child has been removed and placed in foster care, and maybe the grandparent is unable to take that child as and care for them in their home, but they are able to, they would like some visitation with them. If the grandparent can show that they have been a large part of the child's life, they would then have to show that it's in the child's best interest to have visitation with that grandparent. So it's a pretty tough burden. It's difficult for grandparents to ask to have the court issue an order that is against the will of the parent. So parents have a natural right to raise their children as they see fit, and parents have the right to decide who their children are allowed to associate with, including relatives. So if that parent is making a reasonable choice based on their values and their experiences, the grandparent is often unlikely to be successful. When they are successful, the visitation is often limited, maybe once a month, something like that. So when I do consult with folks about grandparent visitation, the advice that I give them is to do their best to keep it out of the court system and try to have the best relationship they can with the parent of the child they're trying to visit, whether it's their own child or the other parent, to mend that relationship and have a positive relationship with the parent. And the parent would then likely want them to have a positive relationship with their child as well. So just a little bit on visitation there, but the rest of my presentation is going to be about kinship caregivers. So kinship caregivers, throughout this presentation, I will often say grandma and mom, because that's really the easiest thing. But when I'm talking about caregivers, I mean grandparents, great-grandparents, aunts and uncles or great-aunts and uncles. They could be adult siblings of the child, maybe a half-sibling. They could even be somebody who's not related to the child, but has played a big role in the child's or the family's life. So maybe mom's best friend when she was growing up, or even, dad's new girlfriend, somebody who's, stable and able to care for the child when the parents are not able to. So like I said, don't be offended but I will say grandma and mom. Although the bulk of our clients here tend to be grandparents, we do see clients with really all types of relationships with children and of all ages too. So we represent people as young. I think my youngest client so far was 20, and that was a sibling of a child. But we would represent people anywhere from 18 to, I would think my oldest client that was caring for a child was 88. So really they run the gamut of ages. So those are the caregivers. Why are these people stepping in to care for children who aren't theirs? So in the U.S., almost 3 million children are being cared for by someone who is not their parent. The majority of these are informal placements, informal caregiving situations. So I'll get into that more in a little bit. But why are some parents unable to care for their kids? There are so many reasons. A lot of what we see, though, is related to substance use and abuse, mental health concerns, domestic violence, where it's repeated domestic violence. So a parent isn't going to be punished solely for being the victim of domestic violence. But if the parent is repeatedly allowing their children to experience that domestic violence, then the child could be removed from the parent. Sometimes the parents have passed away, or they're incapacitated, maybe due to a health concern or an accident, and they're unable to parent. Sometimes they're deployed in the military, and grandma or grandpa need to step in while they're gone. They could be incarcerated. With the opioid epidemic, that is the bulk of the reasons that we're seeing why children are being cared for by somebody other than their parent at this time. Particularly now with the epidemic, people who have been diagnosed with substance use disorder have had more difficulties receiving the care and support that they'd received prior to the pandemic. So they're not able to meet in person like all of us, but they're not having the support that they were getting from Alcoholics Anonymous or NA, Narcotics Anonymous. They may not be able to go for their testing, like a urine drug screening, which might is normally a deterrent for them to use, but if they're not being tested, they may be using again. As we've all seen, that the data is still pretty raw and new, but deaths from opioid overdoses have increased in these last couple of months. We've seen a lot of relapse. I will also say that it's rare that any one of these problems exists in a silo. So often when a parent or really anybody has a substance use problem, they often also have a mental health problem or a domestic violence problem. The overarching problem that is along with these, or maybe even the root cause of these, is poverty and unequal access to things like healthcare, mental health care, substance use treatment, education, those really root issues that we're dealing with. So formal versus informal caregiving. I'm not certain on the numbers. I think it's about 60% of children who are being cared for by somebody other than their parent are in an informal caregiving situation. So this means that the caregiver has not received a court order or they don't have any legal authority to be caring for the child, but they are providing that care. The parent may be living in the household as well, but they may not be able to. Maybe the parent is very young. They could be, still a teenager themselves, or they're in treatment, maybe for substance use disorder, and are unable to care for their child at the time. In those situations, the parent can give permission to the caregiver to help them make medical decisions and educational decisions, things like that for the child. So there's a really useful tool that any parent can use called a Parental Designation form. And I have our contact info at the end of the slide. So if that's something you're interested in and would like a copy of, we can get that to you. So a parent can designate another adult to make medical or educational decisions in their place for a certain period of time. So they can sign this form without a notary, just sign it, and it can be good for up to 30 days. If it's notarized, it can be good for up to 12 months. This is useful even for people who are caring for their own children, but maybe you're going on vacation. So if you're watching this and maybe you're a grandparent who provides care for your grandchildren, I know a lot of people aren't going on vacations these days, but hopefully at some point we're going to be going on vacations again. So maybe you're going to care for your grandchild for a week while mom and dad are out of the state or out of the country. It may be hard for you to reach them and get their consent if there was an emergency. So this is a tool that you could use to have for a specific period of time that would allow you to make decisions for your grandchild or other child you're caring for in case of an emergency. Formal caregiving, when I use that term, that means that there is some type of legal authority given to the caregiver. There's quite a few different ways that this can come about. So sometimes we see grandma, and again, I'm saying grandma, but that could really be anyone who's not a parent. Grandma may notice that something's going on with mom or dad, and maybe the kids haven't been getting to school, or they're not being fed properly, or they just appear unkempt, and grandma checks in and what's going on, and maybe they realize that mom has a substance use issue and they need to step in and help her get some help. So in that situation, grandma often will file a petition in family court. I will get into that a little bit more about the allegations, but so in that situation, grandma, grandpa, the caregiver would go to court and ask the court to give them custody for a set period of time. They might need it just for a little bit of time while mom's getting back on her feet. And that's always the goal, is to get kids back with their parents. And in the meantime, keep them with family. Because research has shown time and again that children have better outcomes when they stay with family rather than when they go with strangers when their parents cannot care for them. Similarly to grandma noticing that there might be an issue, mom or dad might come to grandma and say, I'm struggling. Maybe my partner and I are fighting a lot and it's just not safe for me and my kids, and can you please take them for some time? And maybe they'll go to court together and make an agreement that grandma's going to have custody for some time and help out until their life is more settled and safe. Another way that these come about, I call them safety plans. A lot of people in child welfare call them safety plans. So Child Protective Services may get involved, and there could be a report made that a child is possibly being maltreated. When CPS investigates, their role is to determine if a child is being maltreated. And if the child is, they need to make sure that that child is safe. Sometimes the child cannot remain in the home and be safe. So CPS will talk with the family and help them come up with what's called a safety plan, where maybe mom identifies grandma and says, you know, maybe mom has, maybe she's being evicted from her home, doesn't have anywhere to live, and doesn't want to take them to a homeless shelter. So she says, in the meantime, my mom can care for my kids for the next month while I find housing. And CPS may instruct grandma to go to court and ask for custody in that situation. The third way that a formal caregiving situation could come about would be that CPS, Child Protective Services, does an investigation, notes that the children are not safe, they cannot safely remain in the home with their parent, and they file what's called a neglect or an abuse petition in family court, and they ask the court for an order removing the child from their parent and placing them outside of the home. New York State has long recognized how important families are to children and how much better children fare when they stay with family. So there is a place for foster parents, and foster parents, people who decide to become foster parents, in my opinion, are angels, and I don't know that I could ever do it. But when children have a safe and appropriate family member that can take them in, that reduces trauma for that child and improves their long-term outcomes. So the caseworkers at social services and the courts are constantly looking and trying to find a family member who could take the child, or even at least be a visitation resource, so that that child can have connection with their family while they cannot be with their parent. I don't want to get too involved in all the nitty-gritty, but when a child is placed with a family member through that neglect or abuse proceeding, that caregiver could certify as a foster parent themselves, and they could become a kinship foster parent, which would open up some more benefits to them and the child. But that's getting a little too deep for this presentation. But if anybody has specific questions on that, you can always call our office, and I do have our contact information at the end of this presentation. So I'd briefly like to go over the benefits that are available to kinship caregivers. So only parents are obligated to provide financially for their children. And in New York State, even though custody ends at 18 and people become adults at 18, parents are obligated to support them until they're 21, unless that child self-emancipates, which means they become self-supporting. So it's a little weird that there's two different ages for these things, but parents are obligated until children are 21 in majority of situations. When somebody else is caring for a child, like say grandma's caring for the child, grandma, even if she has custody, is not financially obligated to provide for that child. The parent is still obligated. In almost all of our cases, the parents are not in a position to pay child support. They're often working on their own issues, like I said, such as substance use disorder or mental health issues, and that's their main focus. So they may be working but earning very little, not quite even enough to support themselves, let alone pay child support. So the grandparent or other caregiver can apply to the Department of Social Services for the TANF grant. I'm sure a lot of you are familiar with TANF grants, cash assistance. It's temporary assistance to needy families. So in that situation, the department would look at the child's income, which is almost always zero, and the caregiver can receive a small monthly benefit to help provide for that child. If the household qualifies for SNAP benefits for food stamps, they could add that child to their case and increase their benefits, but only if they qualify. A young child from 0 to, I believe, 6 could receive WIC benefits, Women, Infants, and Children program. And as I had said before, if the child had been removed and placed with a grandparent or other family member, they could certify as a foster parent and receive those benefits. There are significant differences between the foster care benefits for a grandparent versus those cash assistance benefits. It could be a difference of thousands of dollars per month, depending on the child's needs and how many children are in the home. Okay. I'm going to back up a little bit to formal caregiving. So when the case goes to court, so at some point, so even if there's a neglect or an abuse that's been filed, a petition by CPS, at some point that child needs permanency. They can't just stay in this temporary outside of the home placement indefinitely. So the relative caregiver will have to, if the child cannot be returned home, move to adopt the child or take guardianship or custody of the child. When that petition's been filed and when the case is in court, children are assigned their own attorney. And this is another question that I am often asked by people who are involved in family court or even people who are just interested. So in New York, attorneys for children are licensed attorneys, just like me and like every other attorney that you know. And their job is to advocate for what their client wants, just like I do for my adult clients. I have not represented children, but I imagine that it's pretty difficult having these big adult conversations with a child, especially a small child or even a 10 or 15-year-old. But these attorneys do have these conversations with the children and deduce what they want, and they advocate for that in court. They can, in some occasions, do what's called substitute their judgment. So I won't get into the nitty-gritty of that either, but the attorney could advocate for what they believe is in their client's best interest, but almost all of the time they advocate for what the child wants. So I'm often asked, often by parents, maybe it's divorced parents, when does the kid get to pick? When do they get to choose where they live? Or when do they choose to come and see me? Is it when they're 12, when they're 14? When do they get to decide? So as a lot of legal questions are answered, it depends. When courts are deciding what's in the best interest of a child, and that is the judge's decision, what is in the best interest of this child, there are a lot of factors to consider. And this is going off a little bit, but between parents, what is the household of each parent like? What has their involvement with the child been like? What is their stability? So there's quite a lot of factors. And one of those factors is, what does the child want? Each of these factors is given different weight. So if you have a 5-year-old, a little child who's pretty immature, he's only 5, we know what he wants, but that might be given a small amount of weight compared to all of the other factors. But if you have a 15-year-old child who is successful in school and maybe a really mature 15-year-old, and they express what they want, that may be given a lot more weight compared to the other factors. So it really depends. And I know that folks hate hearing that answer, but that's the answer. I would also like to note that, as I've said, it's up to the judge. It's up to the court. What I will say in my experience is that it's very rare that the judge or the court makes that decision. Often, the attorneys and parties, with the guidance of the judge and the judge's law clerk and mediation, reach an agreement together. So as attorneys, we know the law and we know what judges are likely to do and likely in different scenarios. And it's never good for families to go through a hearing. The last thing you want to do, even, let's say I'm mom and my mother is caring for my children. The last thing, even if I'm mad at her, I don't want to hear her say lots of awful things about me on the witness stand or vice versa. So families never come out better if they've had to have a hearing. So even as the attorney, if my client strongly has a great position, I will still try to encourage them to meet somewhere in the middle in a way that can keep all the parties happy and help keep that family whole. Because once I'm out of their life and once the court is out of their lives, they're going to continue to be a family in whatever changed way they are a family. So speaking of changing families, it's a big issue that I didn't see as so much of an issue when I first started doing this work are those changing family dynamics. So, say I have a 5-year-old daughter and I've been raising her for 5 years and I'm her mom and I make all those decisions and I have a stroke. So now my mom steps in and she's caring for my daughter while I'm recovering and healing from this stroke. Now my mom is in more of the mom role to my child. So here's my child. She has to kind of get used to this new relationship with grandma because grandma's not fun grandma anymore. She's more like mom, and she's telling her what to do after school and go to bed early. And mom, me, I've taken more of a back seat. I'm not parenting as much. So maybe I'm having some resentment towards my mom. Maybe my mom is resenting me a little bit because she intended on retiring and now she's raising a 5-year-old. So no matter what precipitates the caregiver having to provide care for a child, there's a ton of feelings that come into play and that really just need to be recognized. And often from both sides, there's a lot of anger and hurt and resentment. I frequently see that the parents initially are thankful that my client, say grandma, has been able to step in and care for the child. But a little time passes and they tend to become resentful and jealous, which is really natural because somebody else is caring for their child. So I am an attorney and I'm giving legal advice, but I'm always aware of those dynamics and counseling my clients on those as well. One other thing that I see that if anyone in the audience today, and I wish I could see you, I'm just here alone in my office and it's such a strange thing to be talking to my screen. I miss presenting in person, but I imagine at least some of you are caring for somebody else. And as Judge Carter will say during his presentation, people in really probably my generation, so I'm almost 40, my parents are in their 60s, my children are maybe 10, 11, 12. I'm caring for my kids, and now maybe I have to care for my parents too. So people in my situation, or even a little bit older than me, I have my own grandchildren, and my parents are still alive and they need my care. So I'm this sandwich generation. I'm still working and I'm caring for children, even teenage children. They're almost harder than babies. And I'm caring for my adult parents. That's causing a ton of stress and anxiety, tired and overworked. I often see a lot of stress and exhaustion in my clients. Sometimes they will neglect their own care. Maybe they stop attending doctor's appointments and don't take their medication as prescribed. Maybe they forget or they can't afford it anymore because they're now caring for the child. As I said, there are benefits available, but the benefits that these folks receive definitely do not meet all the financial needs of kids. Kids are expensive to raise, and $300 or $400 a month is not going to go very far. So, the grandma's reaching into her own pocket and maybe neglecting her own needs. That can lead to burnout, and it can lead to elder abuse, which is what Judge Carter is going to be speaking on shortly. I don't want to villainize parents in these cases. I have a lot of empathy for the parents on my cases, or any parent who's unable to care for their child, because I think almost all of those parents want to be able to care for their child, and they just can't at the moment. But I have seen, in some instances, parents manipulate the grandparents, because that is their parent as well. So there could be some abuse, elder abuse issues related to these kinship cases, and I have seen those. So I think at this point, I will turn it over to Judge Carter, and I will say, if anyone wants to ask any questions, you can type them into the Q&A, and at the end, Judge Carter or I will both take questions. Obviously, he's definitely an expert on this issue as well. So thank you. Afternoon, Judge Carter.
All right. I don't know how many guests we have, but I want to thank everyone for taking the time out to join us. I've listened to Sarah, and it was a wonderful presentation. I'll be honest with you, I learned a little bit myself, so I want to thank you for that. I am a judge here in Erie County Family Court. I've been a judge now for 18 years. Erie County Family Court is located at 1 Niagara Plaza, Buffalo, New York. You could call for information about Erie County Family Court by dialing 716-845-2500, and they will direct you according to your request. What I'm going to do today is talk about abuse, neglect of elders. So we would refer to that as elder abuse. I'll start off by saying if at the end of my talk you believe that you might be a victim of that and you wanted to file a petition, you could file a petition at the address in Erie County Family Court that I provided. And quite frankly, you would go to the 4th floor. We have a petition process center. If you believe that you've been a victim of elder abuse that I will talk about shortly, you would file the petition pursuant to Article 8 of the Family Court Act. It's the New York State Family Court Act. Article 8 governs family offense proceedings. And so in family courts throughout the state, we refer to these types of proceedings as family offense proceedings, and you would file a family offense petition. The family offense petition would be filed by any petitioner who believes that he or she has been or is being victimized by a family member or someone whom they have an intimate relationship with. A family member really includes a family member. Biological family members or anyone that you're living with really would be considered someone that you have an intimate relationship with. And so if it's a significant other or just a friend who you happen to live with, that's an intimate relationship. And if a family member or a friend or a husband or a wife or anyone that they're engaging in some form of elder abuse, you can file a petition seeking what we call redress, okay? There are 6 types of elder abuse. The 6 common types are physical abuse, that is striking, hitting, pushing, shoving. The second type is emotional or psychological abuse, constant badgering, name calling, could be considered that. Threats of some sort could be considered psychological and emotional abuse. Sexual abuse, neglect or abandonment by a caregiver. We'll talk a little bit about that. Financial exploitation, elders who have placed away sums of money and people who have access to that. They exploit the elderly. They use their money. They may not take their money, but say they have some control over their finances and they're using the money to buy things for themselves and not for the elderly. That's a form of abuse. Healthcare fraud and abuse. These are all forms of abuse. Now, oftentimes when I'm talking about elder abuse, I'm asked, well, what age would one be considered an elder? And I tell the story of how, when I was young, I used to look at, when I was 16, 17, I would think of people who were 30, 35 as being elderly. But really, it's an age somewhere around 55. It's not something written in stone, but certainly as you get a little older than 55, the law it looks at you as an elder, okay? And so when we talk about elder abuse, we're talking about people of that age. But as you get older and you become reliant on others to take care of you, we look at those types of people as being elders. You could be in great shape and you could be able to take care of yourself and all of those things, but you reach a certain age of 70, you would be considered an elder. But really, that age of 55 is probably the age where you start thinking and everyone else starts thinking of you as an elder. And so we can at least look at that. Now, you don't have to be that age to file a petition under Article 8 of the Family Court Act if you feel like you're being abused. You don't have to be 55 and older, okay? So I don't want you to walk away thinking that. That would be a misnomer, all right? I say 55 because, it's at that age when we start receiving benefits. Some people say 50 when they get their AARP card. Of course, I tell you a little story about that. I had an AARP card when I turned 50, but I was such an egotist that I didn't want to use it. I didn't want anybody to think that I was an elder. But now that I know I am, it's a wonderful experience. I'll share that with all of you, and I hope that you think the same as I do. Now, the most common type of elder abuse, though, is the emotional and psychological. That happens more often we really would care to mention. And elder abuse is so difficult to detect because a lot of our elderly people are being cared for, and they're not able to get around and about by themselves. They're not leaving the homes often, and so there could be all types of elder abuse taking place, and no one would really know. But from what we've been able to determine from the statistics, emotional and psychological abuse is really the type of elder abuse that happens the most. And if you feel that you've been a victim of that, you could file a petition here in family court. Now, when you file a petition in family court, the court will listen to it. You don't need a lawyer to file a petition. There's no filing fees. The case will oftentimes immediately go before a judge. You don't need a lawyer with you to go before a judge. If it's the case that you can't afford counsel, the courts will refer you to an assigned counsel association, what we call the Indigent Aid to Indigent Prisoners, or what have you. And they may have changed that to just simply assigned counsel. But it's an agency, a law firm, as I like to call it, who has a state funding, county funding, and even federal funding that allows them to appoint and assign lawyers to people who are not able to afford counsel. And so, even though on the first appearance you may not have a lawyer, thereafter you will have a lawyer, so you won't have to go through the process by yourself. With orders of protection, there will be directives that the respondents stay away from the petitioners, refrain from offensive conduct, and that would be conduct that's defined by the New York State Penal Code, such as harassment or disorderly conduct or assault or those kinds of things. And even if the respondent violates the order, there could be some jail time imposed for contempt of court. In addition to that, respondents who violate orders of protection can have petitions filed against them by the or criminal actions, I should say, filed against them by the district attorney's office. And these would be real felony complaints now filed, and they would be looking at significant time. And so there's some real accountability that comes along with that, all right? And as I pointed out, in that case, in the case of filing a petition here, you won't need a lawyer to do that. Once there was a time when elder abuse wasn't as prominent as it is now. It is very prominent, and the statistics are showing that the number is increasing for elder abuse, and there's a number of reasons for that. Primary reason for that is what we've called deinstitutionalization, and what that means is this. At one point, when the elderly would get to a certain age, they would go to facilities, healthcare facilities, or be placed in homes and things of that nature. But it's become so cost prohibitive that now the families can't afford to have them in these specialized housings and all of those things. And so what we're finding now is that families are taking care of their own parents and their own grandparents. And the family members who are taking care of their parents and their own grandparents, they have their own children. And what we're finding is that, it's so stressful to raise your own children in and of itself, let alone having your children to raise and then trying to become care providers for your parents or your grandparents. And then, of course, it's the know-how. It requires a certain level of training and understanding. And, of course, people aren't always trained to be care providers. Care providing isn't the easiest thing in the world. And so with those elements, what we oftentimes find is that it results in some form of elder abuse. In addition to that, economics play a major role. And even though, it appears that the economy may be doing much better than before, there are a lot of people struggling financially, and their care providers, and they're misappropriating their parents or their grandparents' finances. They're not, assuring appropriate living environments. They may go days elderly without the children even looking in on them, and their care providers even looking in on them. And all of these kinds of things are happening at an accelerated pace, and it really truly results in what we call elder abuse. And so when we have the scenario now of elderly not being cared for by people who are trained to do so, we have them living at their homes and being cared for by family members who are inundated and overburdened with their own circumstances. It oftentimes leads to what we call elder abuse. And so it's something that, if you have any knowledge of anyone being victimized or the victim of elder abuse, you should probably, speak with them about that. You should probably do that. Now, in family court, what we see is not only the psychological and the emotional elder abuse, but we're beginning to see more of the financial types of elder abuse in Erie County Family Court. And what you should all be aware of is that, Erie County is really Erie County Family Court, it handles Erie County cases. And so what I've learned after becoming the supervising judge for the 8th Judicial District is that even though we live in close proximity, each county is different. The demographics are different. The population is different. There are counties who have who aren't as populated as Erie County, counties where financially they're much poorer than Erie County, and so you have different types of elder abuse. But in Erie County, the type of elder abuse we see is really psychological and emotional, and we're beginning to see an increase in financial elder abuse. And so I want to now kind of talk a little bit about the COVID crises, COVID-19, the pandemic, and what we've done in the court system to try to address the needs of our litigants. You all know that in early March, really somewhere around March 16, the COVID-19 crises became a major issue for the courts, so much so that we had to rethink how we were going to operate. And in fact, while we never totally shut down, we kind of moved all of our courts into one building, and we began to limit the intake of cases to what we called essential cases. And so an essential case, for example, in elder abuse would be if a care provider was physically abusing the elderly person. That would have been an essential case, okay? If there was some sexual abuse of an elderly person, that would be an essential case. But, if there was some allegation that there was a misappropriation of monies, maybe at that particular point in time, it wasn't considered essential. And so we were hearing the essential matters because we had a limited staff, we had the social distancing that we had to comply with, and so we couldn't have everybody in the buildings. and we couldn't have litigants coming into the buildings until we got it under control. We are definitely much further along today than we were back in March. Now, the other issue was that, getting the petitions before the court required people to actually come into the courts. And it was difficult because of transportation issues. It was difficult because people didn't want to come out into the environment and run the risk of getting COVID. And so since then, we've instituted a new protocol where you could file your actions remotely. You could have your cases heard virtually. What we're doing right now is virtual. And we actually run cases this way, virtually, where we have litigants appearing via Skype or via telephone, and we make records of the appearances and those kinds of things. And so I think we're turning the corner in terms of reopening or becoming fully operational, the courts, even though we're doing virtual appearances. We're doing more than just essential appearances now. And so, for example, if a elderly person wanted to file a family offense petition alleging financial exploitation, where that may not have been considered essential in early March, it doesn't matter now because we're closer to being fully operational, and we're hearing those petitions. And so if you feel that you have a petition or a claim, but you don't want to come into court, arrangements can be made where those petitions are filed virtually or electronically, we call it, and your appearance can be virtual, just as we're appearing today. I know that there was a statement by me about whether or not you need to have a lawyer. You don't. But I always, as a judge, I always recommend and suggest that parties have lawyers. It's kind of like this. When I have medical issues, I go to a doctor. When my car breaks down, I take it to a mechanic. I don't go to Google and read and pretend that I'm a mechanic overnight. When I need my house repaired, I find a way to have somebody who knows how to do the electricity to do it. I don't do that. Now, am I capable of reading up on how to fix things? Absolutely. I can't do surgery on myself, but am I capable of sitting down and trying to understand, some conditions that I have? Absolutely. But do I think it's the wise thing to do? Absolutely not. When I was in law school, one of the first things that I was told was that a person who has himself or herself as a lawyer is a fool. And I never forgot that. And if being a judge, a supervising judge, if I had a legal issue, I would try to get a lawyer. Okay. And so that's why I say, do you need a lawyer? Do you have to have a lawyer? Those are different questions than should you have a lawyer. And my position on that is you should have a lawyer. And for these types of proceedings, unlike the custody proceedings, the visitation proceedings that Sarah talked about, for these kinds of proceedings, you not only have the right to counsel, but your case would be referred to the assigned counsel because you would have the right to have an assigned counsel assigned to represent you. Unlike grandparents seeking custody or visitation, right? So you should be very mindful. My finger got a little... uh-oh.
You should be unmuted, Judge Carter. Oh, no, you're muted again.
Am I unmuted?
You are now, yeah.
Oh, awesome. So now I got to tell you, now I need surgery on my finger. And you all know that I'm not going to perform the surgery myself after what you just heard. Let me just finish up by saying this. When you come to court, you will have your petition reviewed. It will come up to a judge. You will either appear virtually or you'll appear in person. And what happens is the judges will read your petition and they may ask you questions because you're not lawyers and sometimes you don't put everything that's necessary in a petition. And so the judges will ask you questions. And sometimes you may feel that the judge is being mean because of the questions. But the judge really isn't doing that. The judges are trying to ask the questions that they know they need an answer to give you the relief that you're seeking, which would, in the case of these Article 8 proceedings, it would be orders of protection, okay? And so once the judge issues these orders of protection and assign or refer you to the assigned counsel program for a lawyer, or you tell the judge that you're going to have your own lawyer, or you might say, hey, I'm going to represent myself, then the judge will give it a return date, the case. And really, it's a civil proceeding, and the burden is really always on the petitioners, the moving parties, to serve process. In other words, to make sure that the respondents are on notice, okay? And so in the family offense petitions, though, we, the courts, will then send the petition as well as the order of protection to the local law enforcement agencies and ask the local law enforcement agencies to serve the order of protection and to serve the petition on the respondent before the return date. And then on the return date, you come back to court, maybe with your lawyer, maybe not, and the respondent will have counsel. And then the burden of proof is on the petitioner. So just saying that something happened is one thing. It gets you before a judge, and the judge can look at that application based upon what you've said and issue what we call a temporary order of protection, okay? But to get a permanent order of protection, whether it's a 1-year order or a 2-year order or 3, 4, 5-year order, you would have to prove the allegations. And the allegations would have to amount to something the penal code describes as an offense. Again, whether it's disorderly conduct, whether it's harassment, you have to prove facts. You have to put facts and evidence before the court. And you do that by what we call a preponderance, a fair preponderance of the evidence. It's not a criminal case, so it's not beyond a reasonable doubt like you see on television. No, it's something much less than that. So if you said, well, Judge, what does that mean? I would say if you had 100% evidence, a fair preponderance of the evidence is somewhere around 50, 60%. Okay, where beyond a reasonable doubt is closer to 98%, you see? And so that would be your burden of proof. And I think with that, it's if you have any questions, I am ready, willing, and able, just like my friend Sarah there, who's wonderful, to answer those questions.
Thank you, Judge. So there aren't any questions in the Q&A. So I will just go over our resources here. These are just a handful of resources in the area. And I'll give you a quick funny story. Judge Carter is right. I tried to fix my brakes once by myself, watching a YouTube video, and then had to have my car towed to a mechanic. So don't go it alone, and reach out for assistance when you need it. As Judge Carter said, family court is operating a little bit differently. So they do have a help desk that you can still access, although maybe a bit differently. So do reach out to family court. You'll see on the left-hand side are some kinship resources. The first resource is our kinship unit, My email is on there, so if anyone has any specific questions, you can email me or give us a call. The next resource is the New York State Kinship Navigator. They serve all of New York State, and they can answer questions. If anyone is watching this outside of Erie County, that would be a great resource for you to find out what resources are available in your county. And then Erie County Family Court phone number, as Judge Carter had given earlier. On the right-hand column is the phone number for our Elder Abuse Prevention Unit. We helped to establish a legal risk detector app. So this is available. You can do this for yourself or a loved one. A lot of caseworkers use this to evaluate risk and then send referrals to us. There's a local council on elder abuse, and again, the Erie County Family Court phone number. So I would say a great place to start, not only because I work here, but would be the Center for Elder Law and Justice. This PowerPoint and these resources are available. Ms. McKenzie has them and can share them with attendees. So thank you so much, and thank you, Judge Carter.
Well, thank you for inviting me, and I hope all stay safe. Have a wonderful, wonderful day.
Thank you, Judge Carter and Sheriff, for taking the time out to share all the information. I hope everyone learned a lot. Also, for attendees, there is a survey that will show up shortly after the presentation is concluded. And I hope you'll join us again next Wednesday. Our topic will be Know Your Rights when you enter a skilled nursing facility for a short-term rehab. Okay, thank you, everyone.
Thank you so much.
Enjoy the rest of your day.
Bye-bye.